Hello students, this video is being recorded in the summer of 2020, right after the end of the spring semester and in the midst of the ongoing COVID-19 pandemic. Since we do not yet know for sure what format our classes will take in the fall, and since there's some likelihood that at least some of us, both students and faculty, will have to be away from campus for a time should the mitigation plans prove ineffective, or should compliance with or enforcement of public health guidelines prove impossible, I am preparing a video version of each of my lectures for the class to have it ready if and when it is needed. It's also the case that necessary distancing requirements in the classrooms may make it impossible that the entire class can be in the same room at the same time. In that case, those whose turn it is to stay away from campus may find these video lectures a better option than relying on a live classroom feed via Zoom or some other technology. So if you're watching this video, it means that we are, for reasons of public and personal health, still unable to meet together in a traditional face-to-face classroom format. All the same, I'll continue to do my best to teach you what I know with whatever tools I have at my disposal. Enjoy the lecture. So now we move ahead a couple of years, staying with the topic of women's suffrage in the 19th century, and we take a look at Susan B. Anthony's self-defense speech, which is entitled, "Is it a crime for a citizen of the United States to vote?" So we'll first look at the life of Susan B. Anthony, and before we get into some of the details, I want to remark on her birthplace, which is Adams, Massachusetts, also the birthplace of my wife. Here is her home in Adams, Massachusetts, and it's also featured on the postcard in the bottom. The home is in the top right, and on the top left is the Quaker Meeting House in Adams, Massachusetts. And Susan B. Anthony was born into a Quaker family, and so this is where her family attended worship services up till the time she was 6 years old. So Susan B. Anthony was born in Adams, Mass. To a Quaker family. Her father was an abolitionist and also a temperance advocate. The temperance movement was the movement to ban alcohol because of the deleterious effects of alcohol on family life. When she was 6 years old, the family moved to Battenville, New York, and then in 1837, she was sent to Philadelphia to attend a Quaker boarding school. That year, she also began some abolitionist activity collecting petitions against slavery. And in 1845, now Susan B. Anthony was 25 years old, and this photograph of her is from around that time, the family moved to Rochester, New York. In 1846, she was appointed headmistress of the Canajoharie Academy and worked as a teacher. And in 1848, although Susan B. Anthony herself did not attend the convention, both of her parents attended a women's rights convention shortly after the initial Seneca Falls Convention, and both of them signed the Declaration of Sentiments, which was a document that outlined the demands of women's equality in America in the mid-19th century. In 1848, she met Frederick Douglass, with whom she maintained a lifelong friendship, and in 1849, she delivered her first public speech at a temperance meeting. That same year, in 1849, Susan B. Anthony returned to work on the family farm in Rochester, and in 1851, she met Elizabeth Cady Stanton. Together, the two of them maintained a lifelong friendship and working relationship, and both were instrumental in advancing the cause of women's rights in the 19th century. In 1851, she also helped organize an anti-slavery convention in Rochester, New York, and in 1852 attended her first National Women's Rights Convention, which was held in Syracuse. In 1853, she attempted to speak at the New York State Teachers Convention, but was opposed and continued even though some of the organizers of the convention tried to prevent her from speaking. In 1854, two of her brothers emigrated to Kansas, and you may recall from our discussion of Charles Sumner's Crime Against Kansas speech that many anti-slavery citizens from New England and the Northeast moved to Kansas to try to ensure the outcome of an anti-slavery constitution for that territory. In 1856, Susan B. Anthony was appointed New York State agent for the American Anti-Slavery Society. And in 1867, she moved to Kansas herself for about 8 months while she campaigned for female suffrage in Kansas. In 1868, she and Elizabeth Cady Stanton began to publish their women's rights newspaper entitled The Revolution. But in 1869, there was a split in the women's suffrage movement, and it was a split over supporting or not supporting the 15th Amendment. The 15th Amendment gave voting rights to the recently freed slaves, and Susan B. Anthony, who joined the National Women's Suffrage Association, was against the 15th Amendment, not because she was against former slaves voting, but she thought the amendment should also include women. In 1870, women gained voting rights in Wyoming Territory, and they became the first American women to vote. In 1871, the National Women's Suffrage Association adopted a new approach, which is referred to as the New Departure, something we read about in the Jones article in relation to the Victoria Woodhull speech, but they urged members to go and vote on the basis of the 14th Amendment of equal protection under the laws. In 1872, Susan B. Anthony actually voted in the national election in Rochester, New York, and was arrested for doing so. Then in 1873, from February to June, she delivered multiple times throughout the county in which her trial was to take place her speech, "Is it a crime for a citizen to vote?" Then her trial was held in the summer of 1873. She was tried for illegal voting. And then in 1875, what was the basic issue in the trial was decided by the United States Supreme Court in the case of Minor versus Happersett. And in this case, the Supreme Court determined that states could exclude women from voting, that it was not unconstitutional for a state to have such an exclusion or to interpret their own state constitutions as excluding women from voting, and that the 14th Amendment did not grant women the right to vote. In 1876, along with Elizabeth Cady Stanton, Susan B. Anthony wrote the Woman's Declaration of Rights. It was designed to coincide with the centennial of American independence, and it is a document crafted after the model of the Declaration of Independence. And in 1876, she also began writing with Elizabeth Cady Stanton the history of woman suffrage. In 1878, for the first time, a woman's suffrage amendment was introduced into Congress, but of course that was not passed and was not ratified for another 41 years. It's not until 1920 that women earned the right to vote in America. In 1881, she advocated an alliance between the women's rights movement and the Women's Christian Temperance Union. And something that we know from her early life, she was always a temperance advocate. And yet some of her fellow women's rights advocates opposed that alliance. In 1892, with the two national women's rights associations now merged again, Susan B. Anthony was elected president of the National American Women's Suffrage Association. And in 1906, Susan B. Anthony died on the 13th of March in Rochester, New York. So let's take a look at this apologia or speech of self-defense. Is it a crime for a citizen of the United States to vote? So first we could ask about the genre. Susan B. Anthony has been charged with a crime. The crime is voting illegally. She's offering here a defense of her action. So the speech is pretty clearly a forensic effort. And we call it a forensic effort even though she does not deliver the speech in the courtroom. In fact, under the laws in New York in the 1870s, as a criminal defendant, she was not allowed to testify in court. So what she does is offer her defense in various public venues throughout the counties from which the jurors in her trial would be drawn. And so potentially influential was her speech that the federal government actually moved the trial to a different county where jurors may not have been exposed to hearing or reading about her speech. So what is the exigence then in this circumstance? Well, the immediate forensic exigence, of course, is the charge against her. She faces a penalty either of being imprisoned or fined for the act of illegal voting. So she's trying to avoid that penalty and restore her good name. That is, she's trying to maintain the presumption of innocence. We could say that was the immediate forensic exigence. But at the same time also, and this is pretty clear as you read the speech, is that she's trying to make a wider public argument on the question of the injustice of laws that prevent women from engaging in full citizenship and exercising their right to vote. So who then were her audience? We can say that as she travels around delivering the speech, something like 20 or 21 times in Monroe County, that the audience would be immediately all of the potential jurors in the trial, but she's also again speaking to a wider audience. She recognizes that this speech will be covered in the newspapers, and also that as many people who can hear her arguments might be influenced to support women's suffrage. If we talk about the rhetorical audience as being the jurors who will decide her guilt or innocence, we can say in one sense she cannot address them. She's unable to address them in the courtroom. So she has to do that kind of indirectly and preemptively by speaking publicly before her trial. But we also know that she has the long view in mind, that she's thinking about the campaign for women's suffrage and women's rights that goes all the way back to Seneca Falls in 1848 and will continue another almost 50 years past the date of her trial before women gain the right to vote. And then what are the constraints here? Still in 1873, there is widespread prejudice against women speaking in public, although by this time it has happened enough that people are starting to get used to the idea of women engaging on political questions, especially on matters related to abolition, women's rights, temperance, and other educational and prison and asylum reforms. However, there's also still widespread prejudice against the idea of women being political at all, and widespread opposition to the idea of women's suffrage. And so knowing that, Susan B. Anthony has to select a strategy, has to choose resources to use in her speech, argumentative resources and evidentiary resources that will try to transcend that opposition. That is, be able to answer the objections that her fellow citizens might have about women voting in elections. So Susan B. Anthony's trial took place in June of 1873, and it is in the months prior to the trial that she delivers this speech 20 or 21 times throughout the county. But we see here, for instance, one of the New York Times articles about the Susan B. Anthony illegal voting trial. And before we turn to the speech, we'll talk about some of the influences on her argument. As we mentioned, this speech is considered part of that so-called New Departure strategy adopted by the National Women's Suffrage Association. And this idea was that women stopped appealing to Congress to give them the right to vote, but rather now they assumed that they had the right to vote and they had only to go out and exercise that right. That is, they believed that under the new amendments to the Constitution, that there was nothing that the state laws could do to prevent women from voting. And so the idea was to exercise the right that they believed they already have, and then, if necessary, to deal with the opposition to that in the federal courts. And so there are several different attempts prior to the trial of Susan B. Anthony where these arguments are worked out. And one of them is the resolutions introduced by Francis Minor, who was the husband of Virginia Minor. Both of them were suffrage advocates at the 1869 National Women's Suffrage Convention. And this is where the strategy of the New Departure is suggested first. And it's the strategy that's based on the assumption that women have voting rights under the 14th Amendment. This was very similar to the argument made by Victoria Woodhull to the House Judiciary Committee, the speech that we just looked at in our last lesson. And so Susan B. Anthony, who was present when Woodhull delivered her speech to the House Judiciary Committee, also takes up some of the arguments that Victoria Woodhull had used. And in 1871, there was also a federal lawsuit of Sarah Spencer and 70 other women in the District of Columbia, and they sued for the recognition of the female right to vote. So all of these previous speeches influence the arguments that Anthony adopts in her speech before her trial in New York in 1873. So what are some of the critical questions we can ask about the Susan B. Anthony speech? What is the key issue or question being argued by Anthony? And by this we mean, if we understand forensic rhetoric, there are certain sort of stock issues, or what we call forensic points of stasis, on which a legal dispute can turn. And in this instance, we want to look closely at where that argument begins. That is, where do the two sides begin to disagree? Where does the conflict commence in this argument? And then what specific forms of argument does she use to support her claims? We can look closely at how she makes her argument and identify a particular form of argument that she finds is especially useful for someone in her situation. We can also examine the specific inartistic proofs that Anthony uses. That is, what are the documents, what are the laws, what other testimony does she introduce to support her argument that she has the right to vote? And then, how does Anthony anticipate and respond to objections to her position? How does this strategy relate to the organization or structure of the speech? So as we look through the speech, one of the things we notice is that she is familiar with the objections to women's suffrage and even the objections to some of the legal arguments that she's making. And she articulates some of those objections and answers them. And then we could inquire about the attributes of Anthony's ethos. How does this ethos relate to the argument she makes and the general goal of her speech? In other words, what sort of persona or character emerges of Susan B. Anthony in the speech that she delivers? Would you say this is a conservative or a radical speech? And what aspects of it suggest that it's one or the other, or perhaps there are elements of both in the speech? And then what particular rhetorical challenge did Anthony have to overcome simply because she was a female? And we've talked a little bit about this already in connection with Angelina Grimke and in connection with Victoria Woodhull, but certainly by 1873, Susan B. Anthony is facing some of the same obstacles that these other women speakers faced. Here's a photo of her, by the way, seated with Elizabeth Cady Stanton, probably the two founding mothers, if you will, of the women's suffrage movement. So before we turn to the text of the speech, let's take a look at this article by Angela Ray, The Rhetorical Ritual of Citizenship, Women's Voting as Public Performance, from 1868 to 1875. Now, this is a compelling historical and critical study of the public act of voting as a protest about women's suffrage. But it's interesting, too, that there has not been yet a close textual analysis of Susan B. Anthony's speech. So there's an opportunity there for some students, maybe if you go to graduate school, to take up this question, this very important speech in American history, and do that kind of close critical analysis of the speech. But Angela Ray, and we have here the abstract of the Ray essay, Angela Ray is focused on not just Susan B. Anthony's speech, but on the general new departure strategy adopted by the Women's Suffrage Association. So in her abstract, she writes, during the Reconstruction era, hundreds of disenfranchised women throughout the United States attempted to register and to vote, performing a participatory argument in an ongoing public controversy about the parameters of the polity. As rhetorical rituals, these women's voting efforts displayed an alternative social order and illuminated the normative practices of citizenship as profoundly gendered, whereas suffragists' legal rationales for direct action laid claim to citizenship as a universalist category. The intelligibility of the rituals relied on the specificity of cultural conventions. These public performances thus dramatically showcased the power and the limitations of appropriation as a strategy of protest. So that's a fairly complex summary of the article, but the key point here is that when women make the argument about their right to vote, as Susan B. Anthony does in the speech that we're studying here, right, that the idea of citizenship is framed as a universal category. But what the act of attempting to vote shows that is that, in fact, citizenship functions as, in the words of Angela Ray here, profoundly gendered. That is, when women try to transgress those conventions of citizenship as a protest, it exposes the gendered nature of the definitions of citizenship that are in place in America in the public consciousness in the 1860s and 70s. So Ray goes on to say that could a ritual so deeply embedded in the conservation and preservation of political power be productively appropriated for political change? And the ritual she's talking about here, of course, is the ritual of voting. She says, in this essay, I seek to illuminate efforts to appropriate the conventions of the voting ritual for public protest in the late 1860s and the 1870s. Such appropriated rituals were performed as participatory, persuasive argument in an ongoing public controversy about the parameters of the U.S. polity. In other words, one of the things that the act of voting by women achieves as a protest is that it exposes the limits that have been placed on the idea of who belongs in the political sphere or who belongs as a politically active citizen. In order to illustrate the rhetorical power and the cultural significance of such an appropriation of the political ritual of voting, I have examined myriad reports of women's voting performances that appeared in contemporaneous sources. So as Ray is introducing here, she's explaining her method. She looked at, for instance, newspaper stories about people like Susan B. Anthony and the others who attempted to register and to vote, and looked at the language that was used to describe those transgressions of civic conventions. She says, this essay extrapolates from such sources common patterns in the ways in which contemporaries described and explained women's voting efforts, paying special attention to the representations of the dynamic interplay of gender and citizenship. The voting efforts of disenfranchised women, then, were not only the most physically confrontational suffrage activism prior to the parades, pickets, and hunger strikes of the early 20th century, they also showcased the argumentative and tactical conflicts of the women's suffrage movement during the tumultuous Reconstruction era. And so we can see obviously why this study of that act of voting as a protest is relevant to our understanding of Susan B. Anthony's speech of self-defense, in part because it reveals certainly some of the widespread attitudes that would have existed as part of the context in which Anthony is delivering her address. So here's a preview of the essay, and Angela Ray says that the first section explains why and how 19th century suffragists temporarily chose the aggressive strategy of direct action, going to registry offices and polling places and demanding to be accorded full voting rights. Then the essay offers a reading of women's appropriations of the civic ritual of voting as described in the accounts of contemporaries, emphasizing the challenges to citizenship norms embodied in physical action. The final section explicates the power and the limitations of such strategic appropriation. And then she does focus some of her attention on the Susan B. Anthony trial. She notes that the events surrounding Anthony's 1872 vote and subsequent trial were widely publicized at the time and remain the best-known story of the Reconstruction-era voting efforts. The women most likely to undertake public defiance of authorized law had support of strong social networks, and this is certainly true of Susan B. Anthony. And so she asks, just who were these women who chose to perform a ritual of civic participation, electing to defy conventions of a retiring private femininity, and instead to display their bodies as rhetoric, enacting new subjectivities as political agents? She turns further to some of the details about the Susan B. Anthony trial and notes that in Rochester, New York, legal authorities took the initiative in propelling cases into the courts, arresting and indicting Anthony and 14 other women. The rhetorical policing of gendered boundaries was dramatically exposed when the circuit court asserted that Anthony should have been denied registration because she was then and there a person of the female sex, contrary to the form of the statute of the United States of America in such case made and provided, and against the peace of the United States of America and their dignity. As Angela Ray points out, this language enacted the silences that had long remained subtextual amid the celebration of independent male citizenship, implying that Anthony's crime was her sex, the source of threat to law and to public order. And indeed, in connection with this, not only were Susan B. Anthony and the 14 other women charged with illegal voting, but even the young male voting registrar who allowed her to register to vote was tried and convicted of that illegal registration. So now we turn to the speech itself. Is it a crime for a citizen of the United States to vote? And if we go by the document shown here, indeed it was. This is the indictment, the official legal document charging Susan B. Anthony with the crime of illegal voting. So we go to the beginning of the speech, And in the opening sentence, she says, "Friends and fellow citizens, I stand before you tonight under indictment for the alleged crime of having voted at the last presidential election without having a lawful right to vote. It shall be my work this evening to prove to you that in thus voting, I not only committed no crime, but instead simply exercised my citizen's right guaranteed to me and all United States citizens by the national Constitution, beyond the power of any state to deny." So let's take a close look at this opening sentence because it's quite important in understanding the rest of the speech. It is, in essence, the central idea or the thesis of Susan B. Anthony's argument. And we note here that she does not deny voting. So we asked that question before. What is the point of stasis, or the key issue, the point of conflict in this legal trial? It is not a question of fact. She acknowledges the fact. She admits that she voted. What she's doing instead is making an argument on the question of definition. It's a question of whether what she did was illegal, or, in her view, could it be defined instead as simply the exercise of her citizen's right, guaranteed to her by the Constitution. So that's the argument that she's going to make. It's not that she did not vote, but that in voting she was simply exercising the right that she already possessed. And this is, in essence, what the new departure strategy was all about. She goes on to say that our democratic Republican government is based on the idea of the natural right of every individual member thereof to a voice and a vote in making and executing the laws. We assert the province of government to be to secure the people in the enjoyment of their unalienable rights. We throw to the winds the old dogma that government can give rights. Before governments were organized, no one denies that each individual possessed the right to protect his own life, liberty, and property. And when 100 or 1 million people enter into a free government, they do not barter away their natural rights. They simply pledge themselves to protect each other in the enjoyment of them through prescribed judicial and legislative tribunals. They agree to abandon the methods of brute force in the adjustment of their differences and adopt those of civilization. Now we see again in this early paragraph in the speech another important point about the strategy that Susan B. Anthony makes. Look closely at the language here. She's making a natural rights argument. She's using, in essence, the same argument that was used by the founding fathers of the United States when they made an argument against Great Britain and when they adopted the Declaration of Independence. Susan B. Anthony is agreeing with that fundamental principle in American politics, that the rights that we have are natural rights. They are God-given rights, that the rights that we have do not come from the government, but the job of the government is simply to protect or secure the people in their unalienable rights. Even the use of that phrase, unalienable rights, tells us she's echoing the Declaration of Independence. And we see that again in the next sentence where she says, before governments were organized, no one denies that each individual possessed the right to protect his own life, liberty, and property. This was the common expression used before the Declaration, which changed it to life, liberty, and the pursuit of happiness. But again, what Anthony is doing here is articulating that fundamental American principle that our rights are natural and that no government can take away those rights. In fact, all that government can do is to secure those unalienable rights. And then she turns to the idea of the natural right of revolution, which if you cannot affect change in the government through voting, the only recourse left to you is revolution. Again, this is something comes right out of the Declaration of Independence. And Susan B. Anthony says, surely the right of the whole people to vote is here clearly implied. For however destructive in their happiness this government might become, a disfranchised class could neither alter nor abolish it, nor institute a new one, except by the old brute force method of insurrection and rebellion. So let's pause there, because notice again, she's using language that comes right out of the Declaration of Independence, destructive in their happiness, and neither alter nor abolish it, right? These are phrases that echo the Declaration of Independence. One half of the people of this nation today, she says, are utterly powerless to blot from the statute books an unjust law or to write there a new and a just one. The women, dissatisfied as they are with this form of government that enforces taxation without representation, that compels them to obey laws to which they have never given their consent, that imprisons and hangs them without a trial by jury of their peers, that robs them in marriage of the custody of their own persons, wages, and children, are this half of the people left wholly at the mercy of the other half in direct violation of the spirit and letter of the declarations of the framers of this government, every one of which was based on the immutable principle of equal rights to all. And so we see again there this classic argument from the founding era, language that is very similar to language in the Declaration of Independence. The reference, for instance, to taxation without representation, or compelling to obey laws to which they have never given their consent. By those declarations, kings, priests, popes, aristocrats were all alike dethroned and placed on a common level politically with the lowliest born subject or serf. By them, too, men as such were deprived of their divine right to rule and placed on a political level with women. By the practice of those declarations, all class and caste distinction will be abolished, and slave, serf, plebeian, wife, woman, all alike, bound from their subject position to the proud platform of equality. Then we see her turn to the Constitution, and here we might note that in using the Constitution and the Declaration of Independence, we see one form of her employment of inartistic proofs. That is, these are the founding laws, the transcendent organic documents of the nation, and she turns to those documents in support of her argument. She says, the preamble of the federal Constitution says, "We, the people of the United States, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do ordain and establish this Constitution for the United States of America." And then she goes on to interpret that. It was we, the people, not we, the white male citizens, nor yet we, the male citizens, but we, the whole people, who formed this union. And we formed it not to give the blessings of liberty, but to secure them, not to the half of ourselves and the half of our posterity, but to the whole people, women as well as men. And it is a downright mockery to talk to women of their enjoyment of the blessings of liberty while they are denied the use of the only means of securing them provided by this democratic Republican government, the ballot. And she continues a little farther on. The preamble of the Constitution of the State of New York declares the same purpose. Here is not the slightest intimation either of receiving freedom from the United States Constitution or of the state conferring the blessings of liberty upon the people. And the same is true of every one of the 36 state constitutions. Each and all alike declare rights God-given, and that to secure the people in the enjoyment of their inalienable rights is their one and only object in ordaining and establishing government. And all of the state constitutions are equally emphatic in their recognition of the ballot as the means of securing the people in the enjoyment of these rights. So if we look at Anthony's argument, especially from the perspective of a traditional American political creed, we see that she has made an argument that is almost unanswerable, that she has clearly a strong foundation in the founding documents of the nation that support the argument she's making. But we also see here part of the difficulty, for instance, that the abolitionists ran into in trying to make anti-slavery arguments. That is, it's very clear that you can make the argument, but the argument is not enough. The argument doesn't work. Anthony's argument logically and from the point of view of evidence is very strong. But of course, it's not enough to overcome the widespread prejudiced attitudes against women voting, nor to overcome the traditions and conventions of society which left men as the exclusive actors or agents in American politics. A little farther on, she continues, "For any state to make sex a qualification that must ever result in the disfranchisement of one entire half of the people is to pass a bill of attainder or an ex post facto law, and is therefore a violation of the supreme law of the land. By it, the blessings of liberty are forever withheld from women and their female posterity. To them, this government has no just powers derived from the consent of the governed. To them, this government is not a democracy. It is not a republic. It is an odious aristocracy, a hateful oligarchy of sex. But, is urged, the use of the masculine pronouns he, his, and him in all the constitutions and laws is proof that only men were meant to be included in their provisions." She responds, "If you insist on this version of the letter of the law, we shall insist that you be consistent and accept the other horn of the dilemma, which would compel you to exempt women from taxation for the support of the government and from penalties for the violation of laws. I insist," she says, "if government officials may thus manipulate the pronouns to tax, fine, imprison, and hang women, women may take the same liberty with them to secure to themselves their right to a voice in the government." And so we see here, first of all, that one instance of Anthony responding to anticipated objections and answering them very convincingly here, focusing on the language argument, that is, that there's only masculine pronouns used in the Constitution. And she very cleverly responds to that, saying that, in effect, if that's how you want to interpret the Constitution, then women are forever exempt from taxation and from penalties for violation of the law, because those same laws of taxation and criminal law also use masculine pronouns. But we see here also Anthony continuing use of that traditional American political language of the fundamental documents of the Republic. She's talking about, for instance, that women don't enjoy a government derived from the consent of the governed. That's, again, language coming right out of the Declaration of Independence. So here then she arrives at and identifies what is one of the central questions in the dispute. And this was very similar to one of the questions in this anti-slavery campaign. Frederick Douglass, for instance, makes a similar argument in his 4th of July speech. He says, "Shall I argue that slaves are men?" Right? The only question left to be settled now is, are women persons? And I hardly believe any of our opponents will have the hardihood to say they are not. Being persons, then, women are citizens, and no state has a right to make any new law or to enforce any old law that shall abridge their privileges or immunities. This, of course, is what the 14th Amendment to the Constitution guarantees. And so here, again, Anthony is making a very reasoned argument. It's a very carefully argued, logical case in favor of her right to vote. Hence, every discrimination against women in the constitutions and laws of the several states is today null and void, precisely as is every one against Negroes. The question of the citizen's right to vote is settled forever by the 15th Amendment. The citizen's right to vote shall not be denied by the United States nor any state thereof on account of race, color, or previous condition of servitude. So here we see the shift from the 14th to the 15th Amendment, and the 15th Amendment granted former slaves the right to vote. And in that 15th Amendment is the reference to previous condition of servitude, which was slavery. But Susan B. Anthony now turns that to consideration of the women, and she says, can't we understand, of course, that women also are in a condition of servitude? And so doesn't the 15th Amendment also apply to women? How can the state deny or abridge the right of the citizen if the citizen does not possess it? There is no escape from the conclusion that to vote is the citizen's right, and the specifications of race, color, or previous condition of servitude can in no way impair the force of the emphatic assertion that the citizen's right to vote shall not be denied or abridged. Notice here, among other things, the language of careful reasoning. There is no escape from the conclusion. She's done a tight argument drawing on the language, the text of the Constitution to make her case. So she continues then this argument about women's condition of servitude. By the law of every state in this union today, North as well as South, the married woman has no right to the custody and control of her person. The wife belongs to her husband, and if she refuses obedience to his will, he may use moderate correction. And if she doesn't like his moderate correction and attempts to leave his bed and board, the husband may use moderate coercion to bring her back. The little word moderate, you see, is the saving clause for the wife, and would doubtless be overstepped should offended husband administer his correction with the cat o' nine tails or accomplish his coercion with bloodhounds. Here, of course, making a direct analogy to the status or condition of slaves. I will also prove to you that by all the great fundamental principles of our free government, the entire womanhood of the nation is in a condition of servitude, as surely as were our revolutionary fathers when they rebelled against old King George. Women are taxed without representation, governed without their consent, tried and convicted and punished without a jury of their peers. And is all this tyranny any less humiliating and degrading to women under our democratic Republican government today than it was to men under their aristocratic monarchical government 100 years ago? There is not an utterance of old John Adams, John Hancock, or Patrick Henry, but finds a living response in the soul of every intelligent, patriotic woman of the nation. So here again, obviously, invoking the memory of John Adams, John Hancock, Patrick Henry, connecting the cause of women's suffrage by analogy to the cause of American patriots during the Revolution. And this section here serves as a kind of good summary again, like the opening paragraph did, of Susan B. Anthony's whole case, her whole argument. So as we said, she went on a speaking tour delivering this address numerous times throughout the counties where jurors might be drawn for her trial. So let's take a look at what happened at the trial. After both sides had presented their cases in the second day of the trial, the judge delivered his written opinion, which indicates, of course, that he had prepared it ahead of time. He said the Constitution allowed states to prohibit women from voting, and that Anthony was guilty of violating a New York law to that effect. He ruled that the defense had conceded the facts of the case, and he directed the jury to deliver a guilty verdict. And indeed, of course, they did concede the facts of the case. As we saw, Susan B. Anthony did not deny that she voted. She simply made the argument that what she did was exercise her own citizens' rights under the Constitution. But it's interesting that the judge here does not permit the jury to deliberate on that definitional question. He keeps the trial strictly focused on the question of facts and directs the jury to deliver a guilty verdict on that basis. Today, of course, we see how convincing Anthony's argument is, but we cannot anticipate necessarily that the jury would have been enlightened enough to acquit her had they been given the opportunity to deliberate. When Justice Hunt sentenced Anthony to pay a fine of $100, she replied, "I shall never pay $1 of your unjust penalty." And in fact, she never did. But she also wasn't jailed, and that was a key to the appeal process in the case. If Hunt had ordered her to be jailed until she paid the fine, Anthony could have filed a writ of habeas corpus to gain a hearing before the Supreme Court. But Hunt instead announced he would not order her taken into custody, and that closed off that legal avenue for an appeal. Again, it would have been interesting to see had the case gone to the Supreme Court, how they would have decided, but that never happened. A month after the trial, a deputy federal marshal was dispatched to collect Anthony's fine. He reported that a careful search had failed to find any property that could be seized to pay the fine, and the court took no further action. Now, this is interesting too. Maybe perhaps Susan B. Anthony emptied her house of every stick of furniture or something, but it's likely that this was just a sort of pro forma gesture to say, well, we tried, and they're essentially conceding that the fine is never going to be paid, and they didn't want the additional publicity for Susan B. Anthony's protest antics if they had forced her to pay the fine by confiscating personal property. And then let's turn briefly just to a short portion of the transcript from the trial. And this is from directly after the conviction. The judge has directed the jury to find the defendant guilty. And now he's about to pass sentence. And he orders Susan B. Anthony to stand up and says, "Has the prisoner anything to say why sentence shall not be pronounced?" This was sort of the formal, typical, conventional way of leading into the passing of a sentence. And she responded, "Yes, Your Honor, I have many things to say, for in your ordered verdict of guilty, you have trampled underfoot every vital principle of our government. My natural rights, my civil rights, my political rights, my judicial rights are all alike ignored. Robbed of the fundamental privilege of citizenship, I am degraded from the status of a citizen to that of a subject, and not only myself individually, but all of my sex are, by your Honor's verdict, doomed to political subjection under this so-called form of government." The judge interrupts and says, "The court cannot listen to a rehearsal of arguments the prisoner's counsel has already consumed 3 hours in presenting." Susan B. Anthony continues, "May it please Your Honor, I am not arguing the question, but simply stating the reasons why sentence cannot in justice be pronounced against me. Your denial of my citizen's right to vote is the denial of my right of consent as one of the governed, the denial of my right of representation as one of the taxed, the denial of my right to a trial by a jury of my peers as an offender against the law. Therefore, the denial of my sacred rights to life, liberty, property, and here again the judge interrupts her, the court cannot allow the prisoner to go on." So she was prevented from responding even when she was asked if she had anything to say. But we can see here, even in what she did say, that she's drawing on the same arguments and same appeals that she made in her speech. So we'll close here with a letter that Susan B. Anthony wrote to Elizabeth Cady Stanton on November 5th, 1872. just after she returned from the polls and voted. And she wrote, "Dear Mrs. Stanton, well, I have been and gone and done it. Positively voted the Republican ticket straight this AM at 7 o'clock and swore my vote in at that. Was registered on Friday and 15 other women followed just in this ward. Then on Sunday, others, some 20 or 30 other women, tried to register, but all save 2 were refused. All my 3 sisters voted," she says. So if you have any questions or comments about Susan B. Anthony's speech, please post those questions or comments to the discussion board.